Hutsebaut, and I'm a legal advisor at the Transaction Support Centre, a housing advice centre in Makaza, Cape Town. We're very excited to be part of this year's Money Smart Week, and today I'm going to be talking to you about deceased estates and how to transfer property out of a deceased estate. So what is a deceased estate? When somebody passes away, their estate comprises all the assets and liabilities that that person owned at the time of their death. Assets include things like your house, any vehicles you own, any money in the bank, or any other investments. Liabilities include any debts that you owe to any creditors. There are two types of estates in South Africa. There are small estates, which have a total value of 250,000 Rand or less. And then there are large estates, which are estates bigger than that. This distinction will become important as we go through the presentation, as you will see that the processes around these types of estates are very different. This threshold of 250,000 is set by the Minister of Justice and is changed periodically. At the moment it is 250,000, and we will look at it from that perspective. The first process we'll have a look at is deceased estates if the property is less than 250,000. Remember, by property we mean the entire estate, so the house plus anything else that somebody owns. This is a much simpler process, and it is also a more cost-effective process for the people who are responsible for it. The first thing that the family needs to do, the family of the deceased, is to nominate what is called a master's representative, which is the person that the family trusts to administer the estate property. If the deceased left a will, then the master's representative will be named in the will. If not, the family has to agree who that representative will be. The master's representative will need to go along to the local magistrate's court with a set of estate papers, as well as a whole lot of supporting documentation, and report the deceased estate. All this means is that they are notifying the master, who is the body responsible for deceased estates, that that person has passed away and that their estate property needs to be dealt with. The paperwork goes through the master's office, and the first document that is issued from the master is the master's letter of authority. This document allows the master's representative to essentially take control of all the property in the estate and to give directions as to how that property should be distributed to the heirs. A very important document is what is called the next of kin affidavit, also known in the master's office as a J192. This is a document that is completed by the family when they are reporting the estate. And in this document, you are required to stipulate all the family members of the deceased. This can be the wife or husband, if there is one, children, parents, etc. It is very important that full disclosure is made in this document, because this J192 or next of kin affidavit is essentially the document that will ultimately determine which heirs get what. That next of kin affidavit needs to be requested from the master's office in a certified format. And once that document has been received, the master's representative can go ahead and instruct a conveyancer to attend to the transfer of the property. We'll leave aside all the other assets in the estate for the time being, like vehicles and furniture and money in the bank, and just focus on how we actually get the immovable property out of the estate. So the master's representative will need to again prepare a pack of documents to go to the conveyancer, including the very important J192 document received from the master, and the conveyancer will then begin the transfer process. There will be more paperwork to sign at this stage by the master's representative. The conveyancer will need to apply for rates clearance, transfer duty clearance, and a couple of other procedural steps. and then the transfer will be ready to be lodged at the deeds office. The transfer goes through the deeds office and the property is ultimately registered in the name of those heirs who are entitled to the property, either in terms of the will that the deceased left or in terms of the South African laws of intestate succession. The process to be followed if a deceased estate is a large deceased estate, in other words, over the value of 250,000, is a lot longer and unfortunately a lot more costly. Somebody from the family will need to go and again report the deceased estate at the master's office. This includes filling in a complete pack of estate documents and submitting it together with a lot of supporting documents. What is a crucial part of this process is that the master has determined that estates with values over 250,000 should not be dealt with by a family member who is not a professional and who doesn't have experience in deceased estates. So the master will require that a professional person, usually an attorney, doesn't have to be an attorney, is appointed to act as agent on behalf of the family to assist in the winding up process. So when the family reports the deceased estate, they would need to also include an agent's letter confirming who they have appointed to act as agent. Unlike with small estates where master's letters of authority are issued, with large estates they are called letters of executorship, and they are issued, once they are issued, the person appointed in that letter of executorship is allowed to proceed with the winding up of the estate. The agent, which is the party assisting the family, prepares what is called a liquidation and distribution account, which is essentially a document setting out all the assets, all the liabilities of the deceased estate, as well as any debts that are owed and any cash in the estate. That L&D account is advertised for a period of 30 days, which is to allow any creditors of the estate, so anybody who is owed money by the deceased, allows them to come and lodge a claim with that agent. If no claims are lodged, then the L&D account can be submitted to the master's office where it will be examined. And once the master is happy with the L&D account and that no further claims are forthcoming from any creditors, the master will accept the L&D account, and thereafter it will lie for a further 21 days for inspection by the public at the master's office. This is a last bite of the cherry opportunity for creditors to come forward and say, I missed the advertisement, but I do have a claim against the estate. Once that L&D account has lain for inspection and there have been no further objections or claims lodged, the conveyancer can go ahead and transfer the property out of the deceased estate to the heirs in accordance with either the will again, if the deceased left one, or in accordance with the laws of intestate succession. Let's touch on the timelines and costs involved in the winding up of deceased estates. As I've mentioned, both the costs and the timelines are much kinder for smaller estates than they are for large estates. So with a small estate, all that the family would really need to do is pay 50 Rand to the master to request the certified copy of the next of kin affidavit, remember being the crucial document needed to actually pass transfer of the property to the heirs. The family will also need to pay the property transfer costs to the conveyancer. These costs are on a sliding scale depending on the value of the property. There is a possibility that the family could qualify for pro bono costs, which means if they earn below a certain threshold, they may get the benefit of reduced property transfer costs. A further point is if the original title deed for the property has been lost or damaged, the family will also need to apply for a new title deed in order to effect the transfer, and that carries an additional cost of a minimum of 1,500 Rand. The timeline for transfer in a small estate varies, usually around 2 to 3 months, all going according to plan. Some stumbling blocks in this process are the master's office, where sometimes one must wait for documents to come out, and it's really dependent on the capacity of the master's office and how quickly they can issue those documents. A further stumbling block could be that there are rates outstanding on the deceased estate which still need to be sorted out. The family needs to come up with some money to pay arrears city accounts. But all going according to plan. That is the sort of estimated timeline for small estates. Large estates, on the other hand, by law, the agent, so the person appointed to assist the family with the estates, is entitled to charge a fee of up to 3.5% of the value of the estate. This is in the discretion of the agent. They are allowed to do it for less. They may not charge more than 3.5% of the estate value. There are also significant costs, disbursement costs. Those are costs for advertising for creditors, as well as for advertising the L&D account once it's drawn up, and those costs are in the region of 2,500 Rand. And again, if the family cannot find the original title deed for the property, they would need to apply for a new one, which has a minimum cost of at least 1,500 Rand. Unfortunately, the timelines for winding up of large estates is much longer than small estates, and obviously you can see this is because of the various processes that have to happen: the drawing up of the L&D account, the advertising, the line for inspection, and the acceptance by the master. So on a rough estimate, you're looking at probably between 6 and 12 months at best to wind up a large estate. But again, these timelines will vary depending on the capacity of the particular master's office you are dealing with, as well as if there are any other stumbling blocks, such as outstanding rates. These costs are really an indication, and the family of a deceased would need to contact a professional, an attorney or conveyancer, to get a formal quote on actual costs. I'm going to run through a very basic list of the documents you would need to go and report an estate at the master's office. The first document you would need is a copy of the deceased's identity document. If the deceased was married, a copy of their marriage certificate and the ID of their husband or wife. A copy of their death certificate, certified. The original title deed. If the original is not available, a certified copy for the time being, and as well as the ID of the person who is to be appointed as either the master's representative or the executor, depending on the size of the estate. A further document that the master may request is a municipal valuation of the property, because they would want to be able to see at a glance whether this is a small estate or whether this is a large estate. In wrapping up, winding up a deceased estate can be a time-consuming process, and it can unfortunately be costly. But it is very important to note that a property that is registered in a deceased individual's name cannot be legally sold, it cannot be transferred, it cannot be used to raise finance, and the value of that asset remains trapped forever. It is of no use to the family to have that property or to have rights to that property unless that property can actually be registered in the names of the heirs. The longer the family waits to tackle this process, the more complicated and the more costly it can become. Thank you. It's been a pleasure sharing this information about deceased estates with you today. Our details are up on the screen. If you do need any advice, please feel free to give us a call. Thank you.